welcome to We the People. If a child is guilty of committing a horrific adult crime, should he or she still be treated as a child in the eyes of the law? This is the debate on We the People today, not because the law in India is not clear, it is, but because this law is being challenged in the Supreme Court. This after a spate of recent horrific crimes, in particular the Delhi gang rape, after that the rape in Mumbai Shakti Mills, and most recently the rape of a Danish tourist in the capital again, have raised a big public debate about whether juveniles are being treated with kid gloves. But child rights activists say that the law is in consonance with an international convention that children are children, irrespective of their crime, and the juvenile law is clear. 3 years is the maximum punishment. Among those who've gone to court are, of course, the parents of the young woman who was gang raped in Delhi, creating an inflection point for the gender rights movement in this country. Let me start with two people who have actually challenged this in court. We have Aman Hingorani, he's representing Nirbhaya's parents in court, and we also have Subramaniam Swamy, who's taken this right to the Supreme Court. Aman, the centre has responded, and the centre has said that we do not believe that the juvenile who was implicated in the Delhi gang rape can be tried twice. Where does your fight then go from here?
The juvenile has not been tried even once till now. The board is not a court. There's no trial before the board. There is only an inquiry for the purposes of rehabilitation of that particular juvenile.
Are you saying that you completely don't accept the juvenile board as a forum to try this case?
It's not me. The board itself says that we are not a court. If you read the judgment of the board, they say we are not a court, we are not conducting a trial. We are only conducting an inquiry to see whether he is committed this particular offences and how he is to be rehabilitated. Under every juvenile justice system in the world, including India, the premise is a child does not know what he is doing. He doesn't have the ability to take a decision.
Yeah.
Conversely, if a person, regardless of the age, whether it's 14, 16, 18, if that person has the maturity, knows what he's doing, knows the consequences of his action, he can't get immunity.
But the question is, the law in India says otherwise. And unless Parliament actually changes the law.
Here I want to clarify that we have under the Indian Penal Code provisions, section 83 in particular, which says below 7, child can't commit an offence. 7 to 12, the court has to see whether this child had the maturity. If he had the maturity, he will be sent for trial under the Indian Penal Code. Above 12, they anyway have to be treated as adults. Now we have, in 2000, this particular Juvenile Justice Act, which takes away the power of the court to assess the maturity and give the blanket immunity.
So you're saying it should be the discretion of the courts to decide whether to try him under juvenile law or the Indian Penal Code.
And the special law, which, if I may just complete one more second, the special law which gives a blanket immunity to everyone under 18 years, that's unconstitutional. You can't take away judicial power.
But Parliament is at the moment standing by this law, Subramaniam Swamy. And while we have seen individual leaders from the BJP, yourself, Sushma Swaraj and so on, talk about the need to change this law, we can't expect, we're in election season now, there's unlikely to be any change in the law. Now, I'm a little unclear. What are we saying here? Are we saying throughout this law? Or are we saying interpret this law differently?
There were a lot of people after the incident who went to court saying this 18 is wrong. Should be struck down. Now, there were two problems with that. Even if it had been struck down, it would not apply to this particular case. It would be by Article 20 of the Constitution, it will be prospective and not retrospective. But Chief Justice Kabir dismissed all those petitions.
Yes.
The only one that survived was mine, because I didn't challenge the 18 age.
Then what are you challenging?
I challenged the drafting of the Act, saying that the Act, according to the Constitution, Section 253, Article 253, was supposed to accurately reflect the United Nations resolution. And it should have used the words of the United Nations resolution. But it was a truncated it's put up blanket 18. The United Nations resolution, the Convention for the Rights of Child, specifically says 18 unless the crime is heinous. So when it comes to a child stealing a bicycle or a bakery, pastry in a bakery, he should not be clubbed with other criminals, you see, and criminalized, brutalized, etc. But if he takes away the life of somebody or the dignity of somebody through rape, then the rights of that victim also are important.
So you're actually saying that the very interpretation of the United Nations Convention to which
Wrong.
India is a signatory is wrong.
Wrong.
The essence of the argument is determined by crime, not by age.
The argument is that, for example, if you have lowered the age of consent for sex to 16,
yes,
then obviously if a person was 17 years and 11 months, he would have known what he was doing when he was doing the rape. Second, tomorrow if the Pakistanis recruit Indian people, misguided people who are 17 years and 11 months and say go and shoot all 20 people, as it happened with Kasab, who claimed to be a juvenile originally but was rejected, then under Indian law they cannot get more than 3 years. And
so you and Aman Hingorani are arguing.
No, we are not different. We are different. His is a petition not with me. Mine is a petition by itself.
But would you say the essence of your argument is the same?
He is coming on behalf of the parents.
No, I'm not. No, for me, age is irrelevant.
No, aren't both of you saying that determine it not by the age but by the crime?
No.
Aren't both of you saying
that? No, I will say that.
What I'm saying, if I may just say, yes. For me, age is irrelevant. Maturity is the yardstick. As far as this law is concerned,
if there's a 13 or a 15-year-old who commits a murder,
yes,
you're saying whether the person is 15 or 25 is irrelevant.
Irrelevant.
And you are saying what, Dr.
I am
Swami?
saying 18 is the age for juvenile, but for certain crimes, you have to make an exception.
So for heinous crimes, make an exception. Maruk Edinwala, how do you explain to people that somehow a 16-year-old or a 17-year-old who is found guilty, if he is, of rape, should be treated by a maximum of 3 years punishment?
There's this whole misconception that this Juvenile Justice Act mollycoddles the juveniles. It is an extremely lenient law. But what we say is that it is an age-appropriate law. It looks at the circumstances of the juvenile, and that is the reason the focus is on rehabilitation.
What do you mean by age-appropriate law?
By age-appropriate law, I disagree with what was said here because it is extremely clear that there are two concepts. One is the minimum age of criminal responsibility and the other is an age of juvenility. Nobody here is arguing that a 17-year-old or a 16-year-old doesn't know what he's doing.
Then what
of course they know what he is doing. What we are arguing is that it is the characteristic of a child, it is a characteristic of an adolescent, he has behavior which is impulsive. Sometimes he behaves misappropriately. He risk-taking. I mean, there are statistics and there are studies to show them. And that is the reason why you have rehabilitation as the process, because it's just intrinsic in a child.
Is a 17-year-old a child?
An adolescent, yes. And whatever convention you are talking about, please, another thing which was very wrongly said just now is that it does not say that heinous offences should be dealt with differently. The convention is very clear. Please read Article 1. It says 18 is the age, and except if a country has an age of majority which is lower, India's age of majority is 80.
Arima Sundaram, can we disagree, and then I'll come to you, Bharti, can we disagree with the argument? Because we have to also rewind to when we were 16 and 17 and compare the choices that we may make as 40-somethings today to the choices we made at 16 and 17. They were not the same. They were not as mature. That is the argument being made here, that maybe we had some sense of right and wrong, but it was not as well formed as it was in our 20s, as it was in our 30s. So can we just dismiss this argument? But at the same time, I'm struggling with this argument before me that is a 16-year-old the same as a 40-year-old?
Well, there's absolutely no doubt. A 16-year-old and a 40-year-old are completely different. But let's not forget what is the first principle of criminal jurisprudence. It's known as mens rea. Is there an intent to commit a crime or not? Now, if there is an intent to commit a crime, then you know what you're doing, and therefore you are punished for it. Whatever your age may be, you could be 50 years old or 40 years old. And if there is no mens rea, you are not punished for that crime. You see, there are two kinds of crimes. There is one which I would call crimes of aggression. The other would be crimes of circumstance. Now, crimes of aggression, for example, the crime of rape. Now, if at that age, when you say we did many things when we were 16 and 17, I can well imagine pinching something from somewhere, taking a book from somewhere,
stealing a bicycle.
But I don't think any of us have really gone to the extent of committing rapes and murders. Once it's a crime of aggression, you have to view it differently from what are called crimes by circumstance. Because what is pointed out is the Juvenile Justice Act itself was to take into account the circumstance of the child, and therefore to safeguard the child from being thrown into the criminal system when it was like stealing a bicycle or a pastry.
Yes.
But certainly when you're talking about circumstance, I don't think any circumstance would create a rapist. Can I just go one step further?
Yeah, please.
You are absolutely right.
Yeah.
Because even in the case of adults, if it is shown that somebody is mentally unstable, now whatever crime they have committed, they are not punished for it. Why? Because once again the mens rea is not there. So why should the yardstick be different because of a chronological 30 days between 17 years, 11 months, 29 days? You're out, you're clear. Whereas you're 30 days over, 1 day later.
Bharti, would that be acceptable? Would that be acceptable to those who have devoted their lives like yourself to working with children? Because what I'm hearing here is that we are not saying necessarily lower the age from 18 to 16. We're not saying that. We're saying look at the nature and the gravity of the crime.
Before I answer that question, let me put certain facts correct before this audience here and the larger audience that is going to be watching the program. We have only 0.05% of all IPC crimes amount to rapes by juveniles, 0.05%. And 0.04% of all IPC crimes in the country amount to murders by juveniles. We wish to look at statistics the way we want to. We don't look at it the way we should be looking at it from a sociological perspective.
But how would the percentage make a difference?
Let me complete first.
It's all the more reason.
1,678 juveniles altogether in the entire country of 1.2 billion booked for murder and rape in 2012. Having said that, what Aman said some time back, let me also share with you that we recently organized an international conference on juvenile justice, and there were people from the United States, from the State Department of the United States, which very categorically have made presentations and talked about the fact that they've got some 9 million children, juveniles, who are committing crimes, and a lot of it is being attributed to the harsher sentencing policy that they have for the 16 to 18 or whatever waiver systems.
So are you actually trying to say that in countries like the United States, A, the percentage of crimes, serious crimes by juveniles is much higher than it is in India, and B, the harsher sentencing is in turn leading to a higher rate of crime?
That's
is that your argument?
exactly what their research is showing. They are accepting it, they are acknowledging that. And I don't think we can sort of shirk from those researchers.
Okay.
The other thing, certain facts are very, very wrongly put in this forum. Number one, the age of sexual consent today is 18. And number two, the United Nations Convention nowhere talks about dealing with certain categories of children separately, as Maruk had said. The general comment number 10 very clearly talks about a minimum age, but it also talks about a maximum, a higher age, which is 18, and recommends to all countries to go to the higher age, not to anything below the minimum.
So, Prabhat Swami, I think what I'm hearing in these statistics is that are we overstating the incidence of serious crime by juveniles?
On the contrary, if it's only such a small number which is doing these heinous crimes, then treat them differently. First of all, let me tell you, the United States Juvenile Board has now been provided with what is called as a waiver. The judge can decide whether he or she can waive examining that person as a juvenile. The head of the board decides, looking at it, that this is a thing where there is a genuine mens rea, as Sudaram said. And therefore, it must be he cannot be excused on the grounds that he is a juvenile.
So
for example, if it's a terrorist,
now
you have terrorists who are below 18. Now you can't say that, well, you should give him three years in a home and reform him.